If you are a personal injury lawyer, you'll be looking to create the strongest possible cases to secure the best possible outcomes for your clients. The right court of protection expert witness can have a crucial role to play in this. JE Bennett is the founder and managing partner of JE Bennett Law, a specialist court of protection expert witness law firm. Jane, when can an expert witness make a difference?
Siobhan, when I'm instructed as an expert witness in a court of protection matter, this is because there has been an argument that the personal injury lawyer's client lacks capacity, or there is a dispute over whether they may lack capacity or not.
So what sort of testimony does the court of protection expert witness need to provide to add value to the litigator's case?
Clarity on how to view the capacity evidence that has been given to the expert to review, and then clarity on what the options are that are available. So it might mean, for example, that the evidence is suggesting there is a lack of capacity at the moment, but this needs to be reviewed in future, and what other vehicles could be used legally to accommodate that. So, for example, in that instance, you would set out proposed court of protection deputy costs for a professional to be appointed to handle the compensation award, but you would be referencing the need for capacity to be kept under review, which, by the way, it has to be anyway under the Mental Capacity Act 2005. And then you would possibly be considering a vehicle such as a personal injury trust, which can be used as an alternative to a court of protection deputyship, while still providing the injured party with a sort of safeguarding wraparound framework that nonetheless enables them to be more involved in the decision making about their money, because at this point they would have been assessed as having recovered capacity.
So there's sometimes pressure to compromise in discussions with the other side's court of protection expert witness. What's your view on that?
It's great when sometimes you know the person on the other side, and you know how they approach things, and you may know of their firm and their work as court of protection specialists, because quite often you can meet somewhere in the middle with valid arguments on both sides. But I would say largely it might depend on whether I'm acting on the claimant or the defendant side. And I do sometimes do joint reports, by the way, which throws up other ideas. But say I'm acting for the claimant. In that instance, I might have been feeling that I needed to claim as much as possible for the costs of the deputy, and I might have been given a huge swathe of evidence that helps bolster that view. However, if I'm acting on the defence side, I may or may not have been given the same amount of evidence to review. So there's always a sort of peeling away to understand where my opposite number is coming from and how they are justifying as little or as much as they may be doing in their report.
Tell us about the joint reports there. How unusual are they, and where does that change your thought process?
They've been unusual for me in the sense of I have a great many more claimant or defendant instructions than I do joint. But I find joint quite interesting. So everything I say is going to be seen by both sides. And it's an opportunity to kind of think of it from a slightly different angle. If I was for claimant, what would I be putting here? If I was for defence, what would I be saying and why? And where do I think we would meet in the middle, somewhere down the line? So you can kind of jump forward to that position at a much earlier point.
So can that help speed up the litigation process if the case is of a nature that actually both sides might be willing to consider it?
Absolutely. In terms of my input, yes. I wouldn't say as a whole, though.
Something to think about. So finally, what should personal injury lawyers consider when appointing a court of protection expert witness so they can have confidence that the expert witness is going to deliver both for them and for their client?
For me, very personal response to that, Siobhan, and that is a straight bat. I deliver a straight bat because I'm not thinking, I'm on for the claimant, therefore I need to inflate this. And I'm not thinking, if I'm on for the defendant, I need to reduce this. I'm looking at the evidence each and every time. It doesn't matter which side I'm acting on. and I'm applying what I think it would cost if I were appointed in that instance.
You've built a very successful business on that basis, obviously on the integrity and support and trust and expertise you provide for your clients, but also in working with personal injury lawyers. I'm guessing that actually that straight bat is therefore very much appreciated by your fellow professionals.
I think so.
Jane, thank you very much. If you need an experienced court of protection expert witness to help strengthen your cases for your clients, you can email Jane directly. That's jbennett@jebennettlaw.co.uk, or of course have a look at the firm's website for other contact details.